All right, I see it's noon. Welcome everyone. Let's just take another minute or two to let people filter in, but we'll get started in just a second. All right, I think we can get going. Welcome everyone to this next panel called Transparency's Teeth, the best approaches to enforcing freedom of information laws. I'm Michael Lindhorst. I'll be moderating. I'm a media lawyer, former journalist, recently completed a excuse me, a fellowship as a supervising attorney at the Media Freedom and Information Access Clinic at Yale Law School. And I'm pleased to be here with three excellent and knowledgeable panelists. We have Adam Marshall, who's a senior staff attorney at the Reporters Committee for Freedom of the Press. His work includes litigation in federal and state courts and training journalists on government transparency. And he has written extensively about transparency and access to information issues. Then we will hear from Margaret Kwoka, who is the Lawrence Herman Professor in Law at The Ohio State University Moritz College of Law. Previously, she was a professor of law and director of the Information Transparency Project at the University of Denver. Her research interests center on information law, government secrecy, and the administrative law on transparency. And her recent book, Saving the Freedom of Information Act, was published by Cambridge University Press. And then finally, we have A.J. Wagner, who is an assistant professor of journalism and media studies at Marquette University. His research focuses on access to government information, and he teaches a range of journalism and communication courses. He has also served on the OGIS working group of the legislative subcommittee of the 2020 to 2022 Federal FOIA Advisory Committee. So we'll turn to each of the panelists in turn, and everyone in the audience, if you have any questions, please feel free to enter them in the chat or in the Q&A function at the bottom of your screen, and we'll save time at the end to get to as many questions as possible. So first, Adam, I wanted to turn it over to you to talk a bit about your experience with FOIA, litigating FOIAs, other strategies you've pursued to try to get information short of litigation, and some of the common problems you run into with FOIA.
Thanks, Mike. So great to be here with everyone. Oh, I apologize. My cat is also wanting to join us. Just really quick, for those of you who don't have as much experience with the federal FOIA, I wanted to give a quick lay of the land, because the administrative process is similar in some ways to state public records, but different in other ways. FOIA is an outgrowth of the Administrative Procedure Act, so it broadly takes place under the umbrella of administrative law. You put in a request, the agency has 20 working days to provide a substantive determination. It's a bit longer than in a lot of state public records laws. The government can take up to 30 working days for what are termed complex requests. After you get a substantive determination, there's an administrative appeals process where you go essentially higher up within the agency to have someone else take another look if you've received an adverse determination. Parallel to the administrative appeals process, there's also a mediation process that can take place with OGIS, which is called the Office of Government Information Services. It's a non-exclusive alternative to both the administrative appeals process and litigation. However, agency compliance with the OGIS mediation process is voluntary. So sometimes the OGIS process works, sometimes it doesn't. The last step in the administrative process is court review. So if there has been a substantive determination, the court will review that, and the standard of review is de novo, meaning there's no deference given to the administrative process. Also, if the requester didn't receive a timely determination, they can go straight to court. And so I'm going to talk a little bit about that process and two of the big issues that I see with the federal FOIA that is inhibiting its potential as a key democratic tenet of our society. The first issue is delay. Delay is so endemic in the federal FOIA process. Anyone who's ever submitted a FOIA knows this. And it's especially harmful to members of the news media and newsrooms who are trying to get records about issues that are, in the zeitgeist, things that are going on right now. Historians maybe can have a little bit more flexibility when it comes to contemporaneous access, but reporters really do need stuff that's going on right now. So here's some context for you all as we start our discussion. There are about 840,000 FOIA requests that are submitted to the federal government each year. The government rarely, I would say, complies with the time frames that are set forth in the statute. Sometimes for what are called simple requests, the agencies provide a determination more quickly, but by and large, the response time is longer than the statute allows. So for what are called complex requests, the government took more than 100 days to process 20% of all complex requests last fiscal year. And 10% of those requests took more than 200 days to process. And especially if you're trying to report on something that's currently in the news, that's pretty frustrating. Because agencies don't process requests as fast as they come in, there is a backlog of federal FOIA requests that goes up more or less every year. Last year, there were around 153,000 backlogged requests. That's up around 50% from 2013. So the backlogs tend to go up as the number of requests tend to go up, and the number of requests that are processed don't really keep track with that. What happens with backlogged requests? There are lawsuits. So in 2022, there were just under 800 federal FOIA lawsuits that were filed. That's according to the FOIA Project at Track, which is a really great resource for everyone. I encourage you to look at that. Again, for some context, where is that historically? So a decade ago, in 2012, there were just shy of 400 FOIA lawsuits filed. So we're at about double the number of yearly FOIA lawsuits from a decade ago. And that's where things are. Why do people sue? Well, overwhelmingly, it's due to delay. Track, that same resource I just mentioned, they did a study that showed that in 2019, 82% of the lawsuits filed in FOIA cases were because the government simply hadn't provided a substantive response. And that's true of almost all of the FOIA requests that I litigate. So I want to give you an example of one that I wrapped up last year. In the height of the pandemic, ABC News filed a FOIA request with the Treasury Department over records regarding the first round of COVID stimulus checks. And in particular, they wanted records about the decision about whose name was going to go on the memo line of the checks. There was a kind of unprecedented decision to put the president's name on the checks. But there was some back and forth within the agency about that. And there were reports that it actually delayed the checks going out. So ABC filed a FOIA request in April of 2020, and they sought expedited processing, which is a way to try to speed up your request. Not only did Treasury deny them expedited processing, but Treasury told ABC that they had in fact denied expedited processing for all COVID-related FOIA requests. So Treasury didn't respond. Reporters Committee attorneys, including myself, filed a lawsuit on behalf of ABC. And we took it from there. You know, it takes the government about a month to file an answer in litigation. Then there's time to set up a search process and a production process. You know, eventually ABC wrote their first story based on the records that we got them in May of 2021, which is more than a year after the request was submitted. And that's with, you know, litigation and a pretty fast moving news environment. The COVID situation by May 2021 was very different from April 2020. And so it shows how frustrating it can be for members of the news media to try to report on something that is, you know, totally dominating everyone's lives. It takes a year to simply get, you know, enough records to file a story. So what do we see? We see that more lawsuits are filed essentially every year. In the DC federal court here, there was a recent opinion by Judge McFadden that noted that FOIA lawsuits make up about a quarter of all pending civil cases in the federal court in DC. There are about 1,000 pending FOIA lawsuits at any one time now in DC. And that's a lot. That's a lot. So delay is certainly a huge issue when it comes to FOIA. The second kind of pressure point or pain point for requesters are redactions. So just very quickly, I want to give you some context. In FOIA's first few years, so like in the 60s and early 70s, about 1% of requests were denied in part or in full based on a certain exemption. In 2008, that had risen to 22%. In 2016, it was 42%. And 2021, which is the last year we have kind of have full data, 45% of all requests were denied in part or in full based on an exemption. But if you look at the number of requests that are actually processed for release, where records are processed for release, that number is much higher. So in 2021, of all the records requests that are actually processed, 70% of them were denied in part or in full based on an exemption assertion. And that's just an extraordinary assertion. And it's particularly baffling to me, given that in 2016, Congress modified FOIA to include what's called the foreseeable harm standard, which should make it more difficult for agencies to withhold information. But instead, we see the numbers of redactions going up and up. So just very quickly, and then I'll turn it back to Mike. In the ABC FOIA that I was talking about earlier, the agency tried to withhold under the deliberative process privilege mock-ups that they had done of the COVID checks, where they had things like they had President Trump's name on top and then Secretary Mnuchin's name on the bottom. And then they had President Trump's name on the left and Secretary Mnuchin's name on the right. And then they had a version where they included middle initials for the president and the secretary. And then they had all these different permutations. And the agency claimed that disclosing these different mock-ups would irrevocably harm the government's decision-making process. After we filed our brief challenging them, those mock-ups were actually released to us. And you can see them, they're included in ABC's story. But again, this is all after the foreseeable harm standard was enacted. And so I think it shows that the exemptions are still quite a pernicious issue that needs to be addressed. And I hope we can get into some of the ways that we can do that.
Yeah, we will later this hour. And thanks a lot for that introduction, Adam. I'd like to turn now to Margaret to talk more about some of the issues requesters face, sort of at more of a systemic level, because you've written a lot about that, and then some of the approaches that different jurisdictions take to address some of these issues.
Yeah, absolutely. And actually, Adam's comments have probably set up perfectly sort of the two buckets that I see enforcement problems falling into. So one of them is how to enforce deadlines, and the other one is how to enforce disclosure, right? So it's delay and it's exemptions. And actually, I think those are two very different problems that require two very different solutions. And I'll start with delay, which I think it's really a foundational problem. I mean, Adam's description, is horrifying and probably still doesn't even go far enough, right? It is probably the central complaint about FOIA that you hear both from the press and from others, and it's also one that Congress has actually tried to fix and just is failing, right? It's not like Congress hasn't been focused on delay. Almost every round of FOIA amendments, Congress does something to try to tackle delay and backlog. Every year or two, Congress holds oversight hearings, and inevitably the requester community, probably some people on this panel, show up and testify about the horrible problems of delay, and then they pull in some poor FOIA officer from the State Department to answer impossible questions about why it takes so long. And then Congress does things, right? They take it seriously, I think, and everyone appears to be acting in good faith. And so recent reforms have sort of involved creating new carrots and sticks for agencies to meet deadlines, like adjusting fee structures and penalizing them when they don't meet the deadline, and reporting requirements and other kinds of incentives. And I think that these reforms have really missed the mark. It not because they're bad ideas or because we shouldn't necessarily kind of have some sticks and carrots and whatnot, but it suggests that the problem is just agency recalcitrance. Like if we just punish them a little bit more or give them more incentives, they'll clean up their act and do a better job. And agencies' performance will somehow improve. And the work that I've done over the past several years, and including some of the work that was in my book last year, I think really demonstrates that the primary reason for delay is not recalcitrance, but rather just the volume of requesters. And my work shows that we're looking at now government-wide, my best guess, and I've spent really a long time working on this guess, but my best estimate is that there's 2.6% of all requesters are news media, and that's it. Right. So we're hearing a lot of complaints from those requesters who we should be centrally concerned with, because those are the requesters who are doing the kind of central oversight work that we should be most concerned with promoting, and is in fact the goal of this statute. But that's a tiny fraction of who's using FOIA. And so in my book, I detail all the other uses of FOIA that people are engaging, and those are all fine. There's nothing illegitimate or unlawful, and certainly I would never shut them down. But a lot of times we're looking at very routinized information needs for private uses, which are very important uses in many instances, but private, not sort of public oversight, and that have much more sensible ways that we could imagine agencies delivering information. Things like proactive disclosure, right? So affirmative disclosure, where we're ongoing manner publishing whole categories of records that the public routinely needs and wants and is requesting one by one under FOIA, right? Or we could look at portals to get your own information, or we could look at discovery and some administrative proceedings. And I detail a bunch of alternatives in the book, but I think until we take on the problem of volume, I don't know how we solve the problem of delay, because the truth is there's more and more requests every year to the federal government, and they throw more and more money at it, and we're at a stalemate, And so, and in fact, agencies, and I don't think this is nefarious either, I think it's entirely sensible, they're trying to tackle their backlog problem, and the way they do it is they focus more and more and more resources on whatever the most common type of request is. Not news media requests, right? The 60 or 80% of requests they might be getting from, for example, individuals who need their own immigration records, or businesses looking for routine inspection reports, right? They get really good at that and not really good at, the requesters that Adam is representing. So that's the one side where I think if we started thinking about legislation that mandated or incentivized at the very least, or something more of these kinds of alternative ways to get information to the public. Providing information to the public is an inherently governmental function. We should value it across the board, not just shove all of these needs into FOIA. that's sort of the first bucket. And then enforcement on the second bucket, which is exemptions. It's ironic actually that the courts are doing how should I put this, such a terrible job enforcing exemptions, because I actually think that when Congress, originally enacted FOIA in 1966, like Congress really understood seemingly the importance of having independent oversight of agency decisions to withhold records. It focused all of its concern on judicial review, right? So it did things like, as Adam mentioned, right? Unlike in other administrative law contexts where courts are supposed to defer to agency decisions in various ways or give deference to their positions, and review is not particularly stringent, Congress actually provided de novo review, that is, no deference to the agency's position, which was designed to give like real teeth to oversight. And it looks really good on paper, right? Like what could be more independent than the judiciary? What could be better review than de novo review? But it doesn't work well in practice. Adam's story exemplifies one of the big problems, which is it takes forever. Another big, so like to the extent that you have a delay problem, going to court is not your answer. I mean, a lot of people do it because there's no other option, but it's not like it makes it fast. Another problem is that most litigants just can't afford to. Hiring a lawyer is expensive. Pro bono resources are stretched thin. Litigation is resource intensive. Most people can't navigate that process on their own. News media organizations have fewer and fewer resources to do that. Smaller news media outlets have fewer and fewer resources to do that. And so that's a problem. And then the third big problem is that I don't think we've realized even though the courts, of course, are formally very independent, we haven't realized true independence in decision-making. So despite the mandate for de novo review, courts are deferring routinely to agency positions through a variety of sort of what some people have termed like FOIA common law, or like judge-made sort of doctrines around how to process FOIA cases that are sort of procedural mechanisms where the government gets an advantage, or judicially crafted substantive standards under the exemptions that look much more like deference. And we're seeing those decisions, if anything, get worse over time. We've seen Supreme Court decisions recently, giving even broader content to exemptions than the lower courts have traditionally. So that was true of Exemption 4 with trade secret and confidential commercial information in the Food Marketing Institute versus Argus Leader case. We saw an Exemption 5 case that made Exemption 5 broader. So I think we really are, I think the courts are not, and I have various thoughts about why, but the courts are not like the right institution for this role. And so I'm actually spending my year this year, I'm on research leave, and I'm in Mexico studying Mexico's Information Commission model, which is a model of having an independent agency as the overseer. And some advantages of that kind of Information Commission model is include things like having a dedicated body of experts who actually understand information law, with a lot of power to force compliance, real penalties for non-compliance, and the ability to do inspections and oversight in agencies in a meaningful way, in a way that courts just can't. They can't go in and look through the agency's filing cabinets. And so I think there are real advantages to that. And a well-designed model like that would be something to think about. And I know that AJ is going to talk a little bit more about how some of our current institutions might move in a direction like that. But I think that we have to think about, the courts as having been a 60-year experiment in enforcing FOIA that, like, let's acknowledge is not going very well. And courts are great at many things, but I think there are various reasons why this task isn't one of them. And so we should be thinking about alternatives. So I'll let AJ take it from there, because I think he's going to dovetail pretty nicely on that theme. Yeah, I'd love to chat more about how we can make that happen in the US context and some of the experiences I'm learning about abroad.
Yeah, thanks a lot, Mark. And then I'll turn it right over to you, AJ, to talk about different models and the recommendations you've been involved with.
Cool. So I do have a slideshow. I'm a Teams university. I think Erica has the slides, but whether they pop up or not, we'll see. But I'm kind of representing the OGIS working group, which is a part of the National Freedom of Information Act Advisory Committee. Thank you so much, Erica. A committee formed under the auspices of NARA and the Archivist of the United States. And I need to obviously acknowledge the whole group. The chair was Dr. David Collier, familiar to many of you from the University of Arizona, NFOIC board president, Tom Sussman, American Bar Association and NFOIC board member. And then Patricia Weth, she's assistant general counsel for the EPA. And I think that's one of the more interesting elements of working with of the Freedom of Information Advisory Committee is having that necessary ballast of 10 government figures that really help us ground a lot of our ideas. I know Dave and I, and maybe Tom to a lesser extent, have some far-fetched ideas about how some of the things work. It's really instructional and helpful to work with people like Patricia and Kirsten, who's on the call as well, I saw. I've posted the link to the full report. I'm just gonna hit a couple of the highlights. Well, we came with 7 main recommendations you can see there. And I think it probably works best to think of these as 3 buckets. So first, we started with the directive of thinking about how to strengthen OGIS or how to improve OGIS. And it's important to remember what OGIS is and how OGIS was established. It doesn't start hearing or start mediating until 2009. So it's a relatively recent addition to FOIA. And I think it was largely thought of as an enforcement mechanism. And we can think about whether it's been successful or not. It certainly has had lots of positive benefits as far as the number of cases it's resolved and how many cases it's mediated. But it is largely sees itself as a mediating arm of the FOIA, which is important. And we'll come back to that in a little bit. But again, very valuable. But one of the things that we thought about was kind of thinking about how we can increase the enforcement or the authority power. The other piece is thinking about increasing OGIS funding, which kind of dovetails nicely with what Adam and Margaret have been saying as far as volume is a supreme issue, right? And it's been there forever. And one of the ways to deal with it probably is increasing funding and staffing. And then the other piece or the other bucket I want to think about is realigning OGIS. So thinking about how it fits into the government structure, which also might fit nicely with what Margaret was talking about. But as far as increasing OGIS authority, we come up with those first 3. Congress gives OGIS the authority to make binding decisions. This is an enormous step forward in giving more authority to OGIS. And I would, and maybe Kirsten can correct me if I'm wrong, but her and Alina Simo, the director, push back on this a little bit, at least lightly, the idea that OGIS sees itself as a nonpartisan mediating factor, where this would kind of change the role or the position of what OGIS is supposed to do by giving it binding authority to make decisions and make rulings about what cases are before and what they can be done in these enforcement proceedings would be a big step forward in reimagining what OGIS can actually do. Congress giving OGIS the authority to review records in camera. Again, this is bringing more authority into the OGIS office, particularly some of the powers that courts have themselves. Again, this is would be a big step forward in just thinking about what OGIS can and cannot do. Right now, again, they see themselves as a neutral party meeting between a government and a requester, and they try to stay neutral, and they think maintaining that neutrality is a big piece. So thinking about where they expand their investigatory powers, where they increase their binding authority is a big piece. And then OGIS gets extra weight to OGIS decisions. So thinking about Margaret and Adam both discussed the idea that these cases appear before the federal court de novo. This would be the idea that we would rethink some of that, right? They would be instructed via the legislature to consider OGIS decisions with a little bit more weight, which again, a big step forward in thinking about the role that OGIS would have. The next piece would be OGIS funding. And I think this is a big piece. You can think about this more broadly and how FOIA offices are staffed and how FOIA offices are funded. But one of the more interesting pieces of our report, it's page 20, Appendix B of the report that I posted. You can see what the staffing rate of the enforcement mechanisms or the mediating mechanisms across a wide range of nations and states and cities. It's really whatever we could cobble together where we could get a sense of the size of the staff. But you'll have to scroll all the way to the very bottom of the list to recognize that United States staffs OGIS when you think broadly, if you think relative to all these other nation states and cities at the lowest rate by a reasonably good margin. And that's not particularly surprising, as OGIS's staff has remained more or less stagnant since 2009. There's been some fluctuation, but it hasn't added a great deal as far as the size of the staff, yet they continue to hear and mediate more cases each year. So in line with those, creating a direct line item budget for OGIS, this was debate within our working group. There's people in the FOIA community that believe that providing a line item budget gives Congress something to chop when they want to chop it. What we came to as far as a conclusion on where we think about a line item budget, at least now we have a number out there in the open. We can talk about increasing it. We can talk about decreasing it. But right now it all kind of goes on behind the scenes. And again, we think the visibility there would help. And then number 5, an easy one, increasing OGIS's budget. This is something that hasn't happened very frequently and something that could be very beneficial. Again, having a very small staff to continue to serve larger and larger loads of mediated cases is difficult. And, it obviously doesn't improve the product. So again, just increasing the budget, something as simple as that we believe would be beneficial. And then thinking about the role of OGIS and kind of where it fits in. First, the idea is have the Archivist of the United States commission a feasibility study incorporating input from requesters and agencies to more deeply explore the costs and the benefits of these recommendations and refine the proposals to aid in drafting legislation. This is more or less just an idea of having OGIS put together a more fine-tuned approach to what we're putting forward today. And then number 7, Archivist of the United States returns OGIS as a direct report. Currently, OGIS is under Agency Services Division, which is 2 levels of reporting removed from the Archivist. So it must compete for interest, dollars, the attention of the Archivist. So again, just giving it more authority, more visibility, we believe would be beneficial and valuable. We have 2 more buckets in the paper. If you look down lower in the paper, you'll see that first there's 10 more possible recommendations of kind of reasonable ideas that we thought might benefit in reimagining OGIS. And then we also thought about another 14 pie in the sky ones that are at the very bottom. But the 10 are, again, a little bit more closer to possibly realization. Authority to sue agencies to clarify the law. The idea here is to establishing meaningful case law where there is ambiguity and allowing OGIS to go ahead and bring a case when they see it fit. Provide protections for the hiring and the dismissal of the OGIS director. It's important to note that the current director, Alina Simo, does not see this as a problem, but along with more authority comes more exposure and more scrutiny. And the idea here is to create procedures that would help shield against political pressures, both in appointment and dismissal. This kind of comes part and parcel with the idea of increasing authority and enforcement, the idea that this would become a more political position and might require more protection. The idea to add additional educational roles to OGIS, give them responsibility for training all federal executive branch employees, and then also to give them a responsibility for providing public education on FOIA. Again, this is just kind of increasing the size and the scope of what OGIS does and going from what is a small mediation office to something much bigger and taking on a more public-facing role as far as training and public education. Another idea is, and then I think this is kind of where we start thinking about how big can we go as far as where OGIS goes. And the idea first is to move it outside of the executive branch, increase the independence of the office. The Archivists of the United States have been fair and responsive regarding OGIS and FOIA issues, but moving it to an independent status increases visibility and autonomy, which again, just gives it more power, more ability to make important and difficult decisions. And then consider a new resolution model that is neither mediation nor lawsuits in federal court system. And again, Adam said 1/4 of the federal cases, I didn't catch the full caveat on that, are FOIA cases. And this is the idea of trying to take those out of the typical line and move it into a special court. In particular, Ohio has established a court of claims fast lane effectively for state FOI issues that's been very, very successful. They have a single judge that oversees all state level FOI disputes. And obviously similar type of courts have been set up for international trade and patent disputes along with foreign intelligence. So again, the idea is to expedite cases and add expertise and knowledge to the adjudication by creating a special court, or it could be considered under a different powers or authorities, I suppose. But the idea again would be creating something similar to what we've seen in Ohio, which has been fairly successful. I encourage you to look at the 14 pie in the sky suggestions. Again, some of those aren't particularly feasible or applicable or anywhere near in the future. But again, we tried to think very broadly about how we could reimagine OGIS, and that was just a handful of the ideas that we had come up with. So I'm happy to return power to Michael and open it up to questions, I suppose.
Yeah, thanks a lot, AJ. I had one question, and then we had a question from the audience too for you. The first one is just where these proposals stand now, and what you think might happen with them down the road. And then the second question is about OGIS's history, really. And you mentioned it was meant to be an enforcement mechanism, but where's that come from? What's the history of OGIS, and what was it intended to be?
OGIS is a product of the 2007 FOIA amendments, I believe. And again, the idea is it was going to be a mediation arm. I want to say its scale of responsibility expanded with the 2016 amendments. But you can see a little bit of there's a background in the beginning of that report that kind of gives a little bit of an idea of where OGIS came from and kind of where it's going. As far as the proposals goes, these are among many recommendations that came from the advisory committees last term. And you can actually track how these recommendations are accepted and what are done with them. And I don't have the link, but I can look it up real quick. But Kirsten Mitchell does a great, thank you, Kirsten. It's right there. And it shows not only the recommendations of the most recent terms, but all the way back to the beginning of the advisory committee. So as far as the individual 7 recommendations, these are at the very beginning, and obviously they vary recommendation by recommendation. Some are probably more close to realization than others. But as far as them bit by bit or piece by piece being installed, they are ideas at this point.
Great. And I wanted to turn back to Margaret now. First, to get any thoughts you have about these recommendations based on your research about different jurisdictions models. But I also wanted to ask a bit more about the Mexico model that you were talking about, and specifically what penalties that agency has, how it enforces its decisions, and whether you think the Mexico model is a realistic option for the U.S. federal system, given constitutional constraints and the like.
Yeah, absolutely. So, I mean, the first one, there's actually a variety of sort of penalties for non-compliance, which can be levied against the individual agency officers making decisions to withhold records. You can think of those as, warranted or not warranted, or you can think they're too harsh or not too harsh. But I will say, and I'm sort of at the beginning of my year here, so maybe, put a pin in that, and at the end I'll have more thoughts about it. But from what I can tell from preliminary conversations, it's a real deterrent, right? So, I mean, there's sort of like an old adage that gets passed around in the FOIA community about how no one's ever gotten promoted because they answered a FOIA request really well, right? And I think that's the problem, is that a lot of times there's sort of not really a cost on the individual level to withholding records, but the downside wrongly, but the downside to possibly releasing something wrongly can be high, and that calculation is a difficult one. I think partly, So anyway, there are penalties that go against the agencies. There's penalties that go against the individuals, including financial ones. And then, on the second part of the question, a lot of what AJ was talking about, like if fully implemented, this set of recommendations about OGIS would look a lot like sort of what I could imagine happening in the US in terms of an information commission. I mean, there's like some details, some stuff around the edges, but it has a lot of those elements, right? It's sort of like binding decision-making of power. Like I would make it a model where FOIA was delegated to the agency for interpretation so that it was entitled to receive Chevron deference and other kinds of deference doctrines, right? From the courts. I think there's a lot of evidence that agencies generally have more ability to act in a mission-driven way than courts do, right? Where agencies take on the mission of the statutes that they're administering as sort of an institutional design question. And so it gets a lot of the way there, not all the way there, but a lot of the way there. I mean, we could imagine other ways that the Information Commission could also be harnessed. So here, one of the really powerful things is that there's a central requesting portal that the Information Commission administers. And so all requests are funneled through that system, and there's monitoring sort of system-wide, even absent complaints, of compliance. Right. And so it also has sort of just an internal oversight auditing function. Also, that means there's really good data on what's going on. And so it's easier to study and see problems and address them than it is where every agency of, what are we talking about? Like 100 and whatever agencies reporting on FOIA, or so, if you break down components, like 400 some odd components separately reporting on their FOIA activities. And so, you could imagine actually, whether it's OGIS reinvented or whether it's a new thing that replaces OGIS or whatever you want it to be, you could imagine empowering it to do some other really important functions in terms of administering the law on a practical level that would be really salutary. I mean, I think, at this point, where the technology capabilities we should have vastly exceeded where we're actually at on FOIA. And so we could harness that with a specialized agency, I think. Just a couple of the ways, but like I said, I think, when I saw the OGIS recommendations come out that AJ was talking about, I thought to myself, well, this is, there it is. Like, this is the next big leap, right? And then you can kind of work from there. That might be one way to get there. There's certainly, I guess I shouldn't minimize, right? Like, we have issues right now percolating through the courts about independent agencies and the constitutionality of some of the designs of those agencies. That's a concern I think we have to be thinking about when we think about institutional design, just to make sure that we're protecting against, what might be coming down the line. I recognize that Chevron deference, which I just referenced, is maybe not long for this world. It's hard to say. So, I mean, there are ways in which the state of the law right now is in flux that matter, but I think we can think intelligently about how to plan for those possibilities.
Great. Yeah, thank you for that. Thank you for that. I wanted to turn to a question from the audience about the Office of Information Policy at DOJ, and maybe I'm not sure who would be best to answer this question, but maybe first a little background on what that office does and what authorities it has, and then how that office might come into play with different reform proposals.
Mike, I can try to answer some of that. So the Office of Information Policy is an entity within the Department of Justice, and it wears many hats. Many hats. It is the kind of point of contact for processing FOIA requests for some components of the Department of Justice. So, for example, the Attorney General's office. OIP is also the kind of repository where all agencies send their FOIA stats at the end of every fiscal year. How many FOIA requests do they process, those types of things. And then OIP compiles and releases that data in various ways. OIP also does some training and answers questions for federal agencies when it comes to FOIA. So there are lots of different things that go on here. I think it's fair to say that there is some tension between the responsibilities of OIP, which has historically taken on the kind of de facto role of FOIA, government-wide FOIA administration and compliance, And then OGIS, which was, as was said, established as part of the 2007 amendments, and was given a lot of the responsibility that I think that OIP had traditionally had. And so there is some tension, I think, still that's unresolved between those different agencies. I mean, there's a question here about I think it's in the chat about sanctioning FOIA officers for noncompliance. OIP does not have statutory authority to do that, as far as I know. There is a provision in FOIA. It's very, very rarely even referenced. But it says that when a court issues a finding that the agency may have acted arbitrarily and capriciously in responding to a FOIA request, and the court also levies attorney's fees against the agency in the context of a lawsuit, then there can be a referral to the Office of Special Counsel, which is not the special counsel that most of us probably know and think about. It's a separate independent agency. They mostly handle whistleblower related issues. And OSC can then do an investigation and possibly make disciplinary recommendations. I think in the entire history of FOIA, which is 50 plus years now, it's been invoked once, maybe twice, and I don't think anything has ever come of it. In part because I think that the prerequisites to making the referral are pretty high. So that there is so in some there is a mechanism theoretically in the law for this to happen. It's only in the context of litigation, only if there are a lot of things that happen, and it's never really panned out. I do want to say, though, another possible route to reform that we haven't talked about in great detail yet is attorneys' fees. So I think there was a question in the chat about, what can we learn from states, or what states are good at doing this? I have found that Washington State is actually pretty good when it comes to responses to records requests. I think that part of the reason for that is that in Washington State, not only are attorney fees mandatory once you get into court, but there are additional penalties of up to $100 per record per day that the records were improperly denied to the requester. And Professor Div Collier, who I think is on the chat, has actually done some research showing that in states, there's a positive correlation with, and a statistically significant showing that states that tend to have more aggressive attorneys' fees provision, i.e. mandatory attorneys' fees, tend to get better responses to records requests than states where there are only permissive mandatory fees or no attorney's fees. And so I think there is, and there should be room in our discussions about, obviously there are carrots that have to go into all of this. Agencies absolutely need more resources, but what are the sticks on the other end that we can use to maybe promote systemic reform on the back end?
Yeah, and I just want to add into that. Not to plug my own research, but I do find one of the things I looked at when I submitted 1,000 requests across 10 different states was I looked specifically at enforcement mechanisms across those 10 states, and that was not statistically significant. What was, and I'm going to preach to the choir here, was independent, like a nonprofit FOIC type organization that kept that pressure on and kind of teased that out a little bit and looked at kind of why that might be meaningful and why that might be powerful, especially at the state level. But responsive, often these have lawyers. It's kind of like local RCFPs. Where these do get results, and they did across 1,000 requests. So I think there are interesting pieces, but the problem is they're so diffuse. And like we talk about what Adams has seen as being successful, and what Margaret sees in Mexico, and what she saw in her look at all of the request logs. It's hard to find that silver bullet, right? We find that there's many different things that work in different places. But I think that's kind of where the law is the law is so multifaceted and allows for such a wide range of requests. It's hard to find, the silver bullet, I suppose.
Yeah, so I wanted to ask a couple of questions about budgets. The first is following up on your discussion about attorneys' fees and penalties, and who actually pays those. Does it come out of the general coffers somewhere, or is the agency required to pay the fee in a way that might really cause the agency to feel some pressure? That's question number one. And then question number two, Margaret had mentioned how even increasing agency FOIA response budgets hasn't done a lot to address backlogs and wait times. And I wonder why that is. One would think that with increasing request volumes, then increasing budgets would be sufficient to address those requests.
I'll let Margaret take that first.
Sure. Yeah. On that last point, I think we have seen just an increasing with some fluctuation, but mostly an overall just steady increase in the number of requests year over year over time. So I think partly it's just a matter of keeping up. But when you look inside agency FOIA operations, you also see records are more voluminous. Each request is more pages on average over time, right? There is more records of everything being done, even in the context. The most voluminous kind of request we have across the federal government is individuals seeking their own immigration records. The vast majority of those are from the Department of Homeland Security components of USCIS, ICE, and CBP, though there are some other places in the federal government where you see those too. And for those requests, I went and looked at their processing facility, and now on average, an A file, which is the official immigration record of a non-citizen, is now, I'm pulling this number, it's not in front of me, so this is not going to be precise, but it's something like now the average file is like 250 pages, whereas 10, 15 years ago we were at like 100 pages, and 30 years ago we were at like less. So I think part of it is actually just the volume of records we're talking about, information that the government holds, and we're not looking at structural ways to change how we store and access that information that could capitalize on any efficiencies. We're still just processing them page by page with sometimes better redaction software, and that's about it. And so I think it legitimately hasn't been enough to keep up with the problem. I mean, I'm not saying that there might not be some other concerns in certain cases, and certainly we sometimes see high-profile examples of political interference with FOIA requests. I'm not saying that we never have sort of malfeasance that's intentional, but a lot of the ordinary delay, I think, is just ordinary delay. And so I think that's why the budget solutions just haven't been enough. We do need budget solutions. I'll say one more thing about budget, which is we should be thinking about not just better resourcing FOIA offices, which we should, but allocating special big number startup funds to start conversion processes to convert to other systems of information delivery, because a lot of those require a big upfront investment, and no one has slack in their budget sort of sitting around to start a brand new project that no law requires. And so I think when we're thinking about FOIA budgets, we also have to think about Congress allocating money specifically for example, electronic health records at the VA so that people can get it through a portal, or specifically for publishing databases of FDA facilities inspection reports in totem so that we don't have thousands of such requests a year, right? So I think, but it's hard to do that. You need a bunch of money for like some good IT resources and someone to digitize things that might not be digitized, or to convert to a system, and to think about security and all of those things. So I think that's why budget isn't doing it. That was probably a very long-winded way of responding to your question, but I think that's the problem.
And to build on what Margaret was saying, I mean, the cost of FOIA has gone up over the years, but not that much. So I was just pulling the latest numbers. In 2013, it was at about $420 million for all FOIA staff across the federal government. 2021, we're at $520 million. So it's gone up $100 million over almost a decade. I mean, $520 million for all of FOIA across the federal government. as a percentage of the overall federal budget. I mean, I don't know what that is, but it's a tiny, tiny, tiny percentage. And I think it would be really interesting to see, Margaret, based on like Mexico or other jurisdictions, like how much money are they spending on FOIA? Because I suspect, like with OGIS, the United States is just devoting vastly, vastly insufficient resources. Some of these things can be solved with technology, right? Better getting agencies e-discovery software to do redactions. But a lot of it is just like people. We need like people to like look at things and like do stuff. And so, you know, I do feel for agencies sometimes where they're just caught between these things. I do think that having mandatory attorney's fees. Oh, and Mike, in response to your question, attorney's fees come out of the agency's budget. It may depend a little bit on the agency where it comes from, but it generally comes out of the agency's budget. But I do think if you have mandatory attorney's fees, it's going to become a pain point pretty quickly, and it will incentivize agencies to come up with more solutions, to allocate more money, to ask for more money from Congress. And so I think we can do both. I think we can push Congress to give more money, and I think we can encourage agencies to ask for more money.
And one more thing to think about when we think about budgeting is that fees collected are nosediving, the amount that they collect. And I think this is probably tied to 2007, where they added a stipulation that you can't collect fees if you miss the 20-day deadline. So again, trying to encourage meeting deadlines has resulted in, and you know, you could point a number of fingers at what caused this. It could be they've determined that it's not worth chasing fees and assigning fees and playing that whole game. But like the amount of fees, and I don't have the figures in front of me, has diminished dramatically over the last 10, 15 years. So if you think about like where the money is coming from, they also have to fix that budget shortfall that's coming, assuming that they're actually making a profit off of fees, which not a profit necessarily, but recouping expenses, which, you know, that's hard to say. But that's something worth considering when we think about the budgeting and thinking about where we go. And I think that's where I really appreciate what Margaret's saying, is we need to rethink things. The eFOIA was passed in '96. It's almost time for like an eFOIA part 2, right? Where we really rethink what we're trying to accomplish here, and doing so with an understanding of what digital records and digital record transfer looks like in 2022, because it's a paper-based system, right? And we need to move beyond that. And I think Margaret was really instructive in thinking through some of that stuff.
Yeah, and thank you all. I'm sorry to cut you off, Margaret, but I'm afraid we're over time already. This has been a really interesting discussion and really helpful points. There were a number of additional questions we didn't have time to get to, but thank you to our panelists and everyone in the audience for your participation. It's been really informative. Thanks.